Hello, my name is Ashley Strauss Martin, and I'm the attorney for the Realtors Association of New Mexico. I'm here today to talk to you about the revised Residential Purchase Agreement, RANM Form 2104. Today we will be talking about the next section of the revised purchase agreement. Paragraph 22. The disclaimer paragraph is the same language as used in the previous disclaimer paragraph 18. However, at the bottom of that paragraph, the parties are now required to initial. Paragraph 23, maintenance. The term roofs was added to the list of items that the seller is obligated to maintain. Otherwise, this paragraph has not changed. Paragraph 24, pre-closing walkthrough. In the previous purchase agreement, paragraph 20, the contract provided that the parties would conduct a walkthrough 2 days before the settlement signing date. Now the parties have the option of filling in the number of days prior to the settlement signing date that the walkthrough will take place. In addition, the seller is authorizing that the buyer's inspectors have access during the walkthrough to confirm repairs have been completed to buyer satisfaction. Also, reference to RANM Form 5110, the walkthrough statement, has been added. Paragraph 25, consent to electronic transmission of documents and the use of electronic signatures, has not changed. It remains the same as it was in the previous purchase agreement. Paragraph 26, assignment. Nothing has changed in this section, but as a side note, I'd like to say that contracts, with the exception of personal services contracts, are assignable unless the contract prohibits assignment. Failure of a party to elect that this contract is not assignable will result in it being assignable. This means that the buyer could, before closing, assign his interest in this contract to another party. The other party would step into the shoes of the buyer, would have to perform all the buyer's obligations under the contract, and would receive all the buyer's benefit under the contract. Paragraph 27, definitions. Instead of one long paragraph, each definition has been assigned its own subparagraph. In addition, several new definitions have been added. It is important to note that the definitions paragraph is one of the most important paragraphs in this contract, and that brokers should familiarize themselves with the definitions noted in this paragraph. Paragraph 27A, there's a definition of appraisal now. Appraisal means a current estimated market value of the property is established by a licensed real estate appraiser. In the event the buyer is obtaining a loan, the term refers to an appraisal conducted by a real estate appraiser approved by the lender. Paragraph 27C is the definition of date that specifies that when an actual date is used in the contract, opposed to using so many days from the date of acceptance or so many days from the settlement signing date, then that specific date is the final day for performance. In other words, if the parties agree that 5 days before closing something will occur, and 5 days before closing is a Sunday, then per the definition of days in the contract, the deadline for performance would be extended until Monday. However, if the parties agree that something will occur on January 4th, and January 4th is a Sunday, then there will be no extension of time for performance to occur. It must be completed on or before January 4th. Paragraph 27F, the definition of delivered was clarified. Delivered means personally delivered or delivered by some means where there is evidence of receipt. So if something is being mailed, it must be mailed return receipt requested. If something is being delivered via fax, there needs to be proof the fax went through. If it's being delivered via email, there needs to be some proof that the email went through. Paragraph 27G, there is an explanation of how deadlines can be expressed, either as a calendar date or as a number of days. Paragraph 27K is the definition of fixture. It's a newly added definition, and we have previously discussed that definition. Paragraph 27M is the definition of resolution. This is a newly added definition, and we've previously discussed this definition. Paragraph 27O is a newly added definition of standard exceptions, and we've previously discussed this definition as well. Paragraph 28, risk of loss. There was a slight rewording in the last sentence, but it did not change the meaning. Paragraph 29, flood hazard zone. Nothing changed in this paragraph. It's the same as the previous paragraph 21. Paragraph 30, mediation. A sentence was added to the end of this paragraph that clarifies that the requirement to mediate survives closing on the property. In real property law, the merger doctrine stands for the proposition that the contract for conveyance of the property merges into the deed of conveyance. Therefore, any guarantees made in the contract that are not reflected in the deed are extinguished when the deed is conveyed to the buyer of the property. While provisions of the contract that do not directly relate to the conveyance, such as the requirement to mediate, arguably survive the conveyance without this sentence, it was added to clarify the point so there's no confusion. So if the parties have a dispute over the contract after closing, the parties would be required to first mediate the dispute before proceeding to litigation. In other words, the mediation provision does not just apply to pre-closing disputes, but rather post-closing disputes as well. Paragraph 31, earnest money dispute. This paragraph has been significantly amended. Previously, the paragraph was mostly devoted to the concept of interpleader. It happens so rarely that the title company will initiate such an action that discussion of the concept was unjustified. Realistically, if the parties do not both sign off on an earnest money distribution form, then the title company is not going to release the funds. I get questioned on this regularly. When the contract is so clear that one or the other party is to receive the earnest money, why won't the title company release it to that party? Well, the title company is not in the business of interpreting contracts or in being the fact finder that determines whether a certain provision of the contract has been met or not met. It's just not their job. So the parties either come to a written agreement on the distribution of earnest money, or the parties litigate the issue and bring the title company a judgment from the court dictating who gets the earnest money. That is now reflected in this paragraph 31. Paragraph 32, default. This paragraph has been amended. As discussed, we did clarify that all defaults of the agreement are to be treated as material defaults and what that means. We also eliminated the last line of the paragraph from the previous default paragraph that read, buyer and seller acknowledge and agree that broker will not under any circumstances be responsible for any breach by either party to this agreement. This was removed because in part it was unnecessary and in part it was untrue and therefore unenforceable. As we know, brokers are not parties to the contract. Only the buyer and the seller are parties to the contract. So only the buyer or seller can be responsible to each other for a breach of the agreement. In other words, the seller could not sue the buyer's broker for a breach of this contract. That goes without saying. However, to say that a broker is not responsible to his client or customer for a breach is inaccurate and ultimately unenforceable. For example, if the buyer gives the buyer's broker the earnest money to deposit at the title company and the buyer's broker never does so, the buyer is in breach of the contract. The buyer must answer to the seller for that breach because, again, the buyer's broker is not a party to the contract, but the buyer's broker is responsible for the buyer's breach, and the buyer would likely have a cause of action against his or her broker for negligence or breach of an agreement between the buyer and the buyer's broker. Paragraph 33, attorney fees and cost. There were no changes to this paragraph. Paragraph 34, fair housing. Language was added to clarify that the prohibition of discrimination based on age is for the protection of people with children under 18 years of age and pregnant women. Paragraph 35, counterparts. This paragraph allows a buyer to sign a copy of this agreement and a seller to sign a separate but identical copy of this agreement and to have the two signatures on two separate documents constitute a complete contract. Also, this paragraph is relevant when dealing with multiple buyers or sellers. There were no changes made to this paragraph. Paragraph 36, governing law and venue. This paragraph has been modified. The first sentence basically states that this contract will be construed in accordance with New Mexico law. This seems like it may be completely obvious, but in the law, there is a provision that allows a court to apply the law of another jurisdiction if certain factors are met. This is called the choice of law rule. The parties are hereby agreeing in advance that regardless of the choice of law rule, New Mexico law will apply to the interpretation rights and obligations under this agreement. The second sentence has to do with where an action based on a breach of this contract may be brought. Here, the parties agree that the action will be brought in the county in which the real property is located, even if the real property is not the direct object of this suit. If the suit involves the real property, then New Mexico law requires that the suit be brought in the county in which the real property is located. However, if the suit involves damages arising from the contract, there may be multiple courts in which the action may be brought if the parties reside in different counties. The parties are agreeing in advance that the proper venue for any claim arising out of this contract will be the county in which the property is located. Paragraph 37, severability. This paragraph basically says that if a court finds any of the provisions of this contract invalid or unenforceable for whatever reason, the remainder of the contract remains in full force and effect. This language was not changed. Paragraph 38, multiple buyers. This is new language. I received a couple of calls about this paragraph when word got out that it had been added. It was not well received. I found this interesting because the consequences set forth in this paragraph are the same consequences that existed in our previous purchase agreement, wherein this issue was not specifically addressed. In other words, by the nature of this agreement, the buyers under the agreement are jointly and severally liable. So if one walks away from the contract or passes away or becomes incapacitated before closing, the remaining buyer or buyers are still obligated to perform. The purpose of putting the language in the contract is to bring this to everyone's attention so that if the buyers do not wish to be jointly and severally liable, they could amend the contract accordingly. And if they do amend the contract to eliminate joint and several liability, then the seller can assess whether he wishes to enter into a contract where the buyers are not jointly and severally liable. Paragraph 39, authority of signers. This is new language. Here the buyer and/or seller warrants that if he or she is signing on behalf of a corporation or another type of entity, that he or she has the authority to do so. The non-entity party to the contract may request proof of such authority, but this would have to be addressed in an addendum because no such contingency is built into the contract. As a side note, when a broker is entering into a contract with an entity, such as a listing, buyer-broker, property management, residential rental agreement, or personal guarantee, I always advise the broker to get a copy of the documents giving the person who will be signing the authority to do so. You may make the document an exhibit to the applicable agreement. Paragraph 40. The name of the paragraph was changed to include the fact that the paragraph also specifies that the agreement can only be amended or modified by written agreement of the parties. Otherwise, the language in the introductory paragraph remains the same. Reference to the Homeowners Association addendum was removed because we have since turned the HOA addendum into a seller's HOA disclosure, so it is no longer an addendum. We then added the new seller financing for mortgage and deed of trust addendum, RANM Form 2507. Paragraph 41, expiration of offer. The paragraph was amended to clarify that at any time up until the seller not only accepts but delivers this agreement, the buyer may revoke the offer. Please recall that there is a definition of delivery in the definition section, paragraph 25. Signature blocks. The buyer's signature block remains the same. There's been no changes. As previously noted, the FERPTA acknowledgement box has been removed. The seller's signature blocks have been modified. There are now 3 possibilities. The first box allows the seller to accept the offer as is. Here the seller will sign the agreement. The second box allows the seller to reject the offer and submit either a counteroffer or an invitation to offer, as indicated by the seller. Here the seller will choose the applicable box and is instructed to initial all pages. The third box allows the seller to reject the offer without submitting a counter or invitation to offer. The seller is instructed to check this box, if applicable, and to initial where indicated in the box. The seller does not need to initial each page of the contract. On the topic of initials, let me say that initials on each page are not required to form a legally binding contract. However, they do play an important role should either party claim that they didn't receive and review a page of the purchase agreement, or if they claim that a page has been altered in some way after the party had signed the agreement. The last page of the purchase agreement is where the buyers and sellers brokers identify themselves. We have now added a statement directly above this section that alerts all parties to the fact that the brokers are not parties to this purchase agreement. This concept is not new. Brokers have not been party to this purchase agreement, at least since I've been with RANM. Still, there seems to be some confusion on this point. And that concludes a presentation of the changes to the RANM Residential Purchase Agreement, RANM Form 2104. If you have further questions, please contact me on the RANM Legal Hotline. The number is 1-800-699-7266, or you can send an email to legalhotline@nmrealtor.com or astraussmartin@yahoo.com. Thank you very much and have a wonderful day.